Succession planning is an uncomfortable task that lots of people postpone. At the end of the day, it's one of the most important things you'll do in your lifetime. As such, you should take your time and do it properly. Welcome back to the channel. Today I would like to dive into this crucial yet often overlooked topic. Whether you own a home, have investments, or simply want to ensure your loved ones are taken care of, understanding how to properly plan your estate is essential. My name is Aguinaga, your real estate expert here in Montreal. In this video, we'll explore what happens to your assets if you don't have a will, the complications of unclear wills, and how to create a comprehensive plan that minimizes tax liabilities and avoids unnecessary conflicts. Let's get started. What happens to your assets if you don't have a will? It's a common fallacy that should a person die without leaving a will, their assets are acquired by the government. However, such is far from the truth. The answer to this question depends on who the surviving family members of the deceased are, as the Articles of the Civil Code of Quebec foresees the rules of legal devolution of successions in the event that a person dies ab intestate, without a will. Articles 653 and following. Here are a few scenarios to help clarify this. Scenario 1. Paul is married and has 2 children. Paul's assets will be divided as such: 1/3 unto his surviving spouse, 2/3 divided equally amongst his 2 children. Should he not have had a surviving spouse, then 100% of his assets would have been divided equally amongst his children. Scenario 2. Paul is married, however, he does not have any children. His parents have also both survived him. Paul's assets will be divided as such: 2/3 unto his surviving spouse, 1/3 divided equally amongst his father and mother. Scenario 3 now. Paul is not married, nor does he have any children. His parents have both survived him, just as his brother and sister have as well. Paul's assets will be divided as such: a half divided equally amongst his father and mother, a half divided equally amongst his brother and sister. I hope these scenarios help clarify what happens if you don't have a will. Now, what happens if your will is not clear? Well, should the will be signed before a notary of the province of Quebec, it is rare that the wishes of the testator or testatrix will be stipulated in a matter that is unclear or causes confusion. However, in the event that a clause cannot be interpreted by a legal professional, the court will be asked to intervene. Now, how do you prepare a will properly? Well, the best thing to do is go seek professional advice or a notary. In the event that you choose not to, here are a few pointers that a notary provided me in order to help you draft a will. The first thing is to be sure to clearly identify the person whom you would like your assets to be distributed to, full legal name, and their relationship with you. The next thing to do is, should the will be written without the use of any technological means, it is to be written entirely by hand. It is also very important to include the date the document is being signed, in addition to including the testator's signature. Should the will be signed before 2 witnesses, it is essential that the testator signs the document in the presence of the witnesses, while they also oppose their signature onto the document. It is important to foresee persons to replace the ones already named. For instance, should the testator wish to bequeath all of his property unto his spouse, it is wise to include a clause stipulating to whom the assets will be devolved upon in the event the spouse predeceases the testator. It will be detrimental to the succession if the testator decides to try to sound fancy by using legal terminology to draft their will if they themselves are not legal professionals. Keep the lingo concise and comprehensive, despite it not sounding fancy. It is essential to note that a will that is not signed before a Quebec notary will be subject to probate upon the testator's death. In other words, such a will does not come into effect automatically like a notarial will does, but rather by the application for probate filed with the Superior Court of Quebec or by a Quebec notary. Now, what are the tax liabilities once you die? First and foremost, there is no succession tax to be paid by the heirs upon them receiving the deceased assets. However, the law considers the deceased to have sold all of their property at fair market value immediately before death, cashed out all of their RSPs, and so forth. The deceased successions, represented by the liquidator of the succession, will then be obliged to acquit all of the deceased debts prior to the devolution of the assets unto their heirs. The debt payable in the form of taxes will vary depending on the deceased assets and when they were acquired. It is therefore suggested to seek the professional opinion of the accountant who has filed the deceased taxes in the years following up to their death. Now, a pointer I always like to give people is make sure you get insurance to cover your mortgage. It's always a good idea to get insurance that will at very least cover the mortgage on your principal residence in case of death. While your family is mourning your loss, having the family residence paid off in full is one blessing that cannot be understated. It's one less thing for them to have to think about. The next concept when talking about insurance is get life insurance. If you foresee large tax implications upon death, having an insurance policy to cover these taxes is a great way to protect your assets and your family. Again, you want to minimize additional tasks for them. Now, finally, you want to make sure you have open communication with family members to avoid problems once you are gone. After speaking to a few professionals in this field, the most common surprise they originally had to deal with was how little the family knew about the deceased wishes. I could not believe the fact that somebody was telling me this. So, open lines of communication are critical to avoid making a difficult time even more unbearable. Emotions will be running high, and a large surprise to your family when they are at their weakest would be too much to handle. Be sure to advise your family of what's stipulated in your will so that the death is the only surprise they're dealing with at that time. Now, an interesting question for Quebec: what do common law partners have when it comes to wills? How does it work? How does it impact succession if there is no will? Well, in Quebec, for succession matters, common law spouses are not qualified as spouses in virtue of the Civil Code of Quebec. Consequently, common law spouses have no rights with regard to the legal devolution of the deceased assets. They are not entitled to receive any part of the succession, despite the number of years they would have been in a common law union with the deceased. Now, this is very important to note. A super fancy case had to do with the owner of Cirque du Soleil in Quebec. This is something that people didn't believe, didn't understand, and it really kind of changed the way we did things. So know that if you are in a common law union, you are not entitled to anything upon death, and you want to make sure you understand what this means and how it implicates you. Succession planning might seem like a daunting task, but taking the time to properly plan your estate can bring peace of mind and protect your loved ones from unnecessary stress and financial hardship. I hope you found this video helpful. If you did, please give it a thumbs up, subscribe to the channel for more insightful content, and share it with anyone who might benefit from this information. Remember, it's never too early to start planning for the future. See you in the next video.